on COVID-19 and international trade governance. We have changed the order of the presentation a little bit from the program because we thought it was more logical. So we will first begin with Professor Khorsed Zaman about the proposal for the WTO for a new patent waiver on COVID-19 vaccines and pharmaceuticals, because that's a very topical worldwide issue right now. This will be followed by a presentation by Professor Paola Mariani from Bocconi University on export control measures and affecting trade in goods in the pandemic crisis. And that will look at the situation in the EU member states and the EU towards third countries, including a comparison to the United States. This will then be followed by a presentation by Marcia, Harpaz and Hadas Peled. It will be rather Hadas Peled from Hebrew University and Ilan University. They will present on the global government procurement governance amid the pandemic, so the government procurement aspect of it, WTO law and comparative analysis with other regimes. And finally, we will turn to Professor Davide Giacomo Zoppolato from the University of Macerata in Torino and West Virginia, and maybe some more. The marginalization of the WTO in international trade, nationalization and reshoring answers to the pandemic. So that looks more general, and I thought that was a good topic for the end about anti-globalization, reshoring, and also the situation with China. We will look at that. So with not much more ado, I will first introduce more precisely Professor Khorsed Zaman from Macquarie University in Sydney in Australia. He is an expert in corporations, commercial law, international law, and international trade law. And his main area of expertise lies in international economic law, as we can see from his presentation, investment laws, intellectual property law, which comes in handy for today's presentation. He's also been engaged in a number of projects on multilateral investment facilitation and VRs in Asia and Pacific. So the clock is ticking. We're trying to stick to 8 minutes, and we are all agreed that what is missing from the presentations can be covered later on in the question and answer session. And please, I would invite all participants to post their questions in the chat room. I will look at them, and the speakers will see this, and we will try to answer them right after the presentation or later. Thank you very much. Please commence.
I'm sharing my screen. So good afternoon, everybody. This is a presentation on the TRIPS waiver proposal at WTO. Several developing countries led by India and South Africa submitted a proposal to the WTO in October 2020, requesting a temporary waiver of Section 1, 4, 5, and 7 of Part 2 of the TRIPS relating to COVID-19 vaccines, medicines, diagnostics, and medical technologies. Will use that COVID-19 pharmaceuticals. So if this waiver is granted, then WTO members, they can refuse to implement, apply, and enforce copyright, patent right, industrial designs, and protection of undisclosed information relating to COVID-19 pharmaceuticals. The majority of industrialized nations have been opposing this proposal. So in this presentation, we'll try to explore and examine whether this temporary waiver is essential from the point of WTO law. So is it a new phenomenon at WTO? It is not. It is a recurrent issue at WTO. This waiver proposal is a reminiscent of hotly debated discussion in the WTO TRIPS Council in 2001, when Zimbabwe brought similar type of proposal in the context of waiver of intellectual property rights over HIV and AIDS, and other life-saving drugs. Similar to the current proposal, similar to the current situation, this African country's proposal was rejected initially, mostly by developed countries. But finally, this debate led to the adoption of the Doha Declaration of Treaties and Public Health in November 2001. And on the basis of that, a temporary waiver was granted in 2003. And we all know subsequently, the TRIPS agreement was amended, especially 31F was amended, and a new article was incorporated, which is Article 31 bis. So this waiver is not a new thing. It is an old issue in WTO. Then the question is, do we need another TRIPS waiver now? It depends. A clear answer to this question is a little more difficult. The answer could be yes. The answer could be no. It largely depends on how the WTO members treat existing TRIPS flexibilities in their interaction with other WTO trading partners. So we'll focus on that now. First of all, we want to have a look at what are the existing TRIPS flexibilities. You can see here, shortly, there are basically three types of TRIPS flexibilities that we can refer here in the context of COVID-19 waiver. The first one is LDC's transitional waiver. So LDCs, until 1st January 2033, they are not required to grant, implement, apply, enforce patents or test data protection. So this is one flexibility. LDCs, they are not required to do. The second type of flexibility is Article 30. That includes 30 and 31, basically. That includes compulsory licensing, patent extension, government use of non-commercial purpose. This compulsory license is very relevant in this context. And that is relevant in the context of Article 31F and 31 bis, which is basically exporting pharmaceutical products to countries which are unable to produce. They don't have the capacity to produce. So these are generally the flexibilities. Now we want to have a look at whether these flexibilities are working or not. First of all, if we look at LDC's transitional flexibility, then we can see that this is actually not relevant in this situation, because most of the LDCs and most of the developing countries, even developed countries, they do not have the capacity to produce COVID-19 pharmaceuticals. So waiver is not required because they are not capable. So this is not relevant. The second thing is compulsory licensing. The same thing. This is also not relevant because most of the developed countries, developing countries, they are not able to do that. So mostly relevant in this case is Article 31 bis, how it is working. There are two approaches. You see, one is optimist approach and another is pessimist approach. So some people, they say, like some countries, they believe that, yes, this flexibility might work. So if it is working, if it works, then we may not need a new waiver now. But there do have a lot of flaws in this discourse. The first flaw is the Doha Declaration on TRIPS and Public Health doesn't include COVID-19 issue. So it includes other epidemics that needs a clarification of that. The second thing regarding compulsory licensing, there are two types of use of national security defense under TRIPS. One is under Article 31 and another is Article 73B, subsection 3. And yeah, if we clarify that objectively, that could be complementary, but WTO jurisprudence is not clear enough regarding this issue. So we need some clarification on that particular issue. Again, the third pessimist approach is the experience of exporting drugs under Article 31B. This experience is not good, actually. So the TRIPS waiver, temporary waiver, was made in 2003, and finally it took 5 years to make that happen in 2008, and this experience is not good. Another experience is 37 countries, including OECD countries, most of the OECD countries and developed countries, they do not follow, they rejected this 31B's approval or incorporation of in TRIPS. So these are the issues that is hindering, that is obstructing, that needs to be addressed. Now, finally, in the conclusion, what we can do is, I will conclude this presentation with the answer to this question, with some answers. First is compulsory licensing of COVID-19 pharmaceuticals legal under TRIPS? Yes, legally, yes. Can COVID-19 drug manufactured under compulsory licenses be exported? It's not clear. It can be exported, it may not be exported. There are some hindrance, as I mentioned, especially here, non-inclusion of COVID-19, non-clarification of national security issues, and bad experience regarding Article 31B's and non-cooperation from developed countries. So these issues are the main problem. So finally, the answer is it depends on WTO membership. There is no straightforward answer. If the WTO membership follows the optimistic approach, maybe we do not need any waiver. But if that is not followed, that means if TRIPS flexibilities are not used properly, then maybe we need a waiver. But for sure, in any case, WTO needs to clarify some pertinent issues that is mentioned in this presentation. So that's all from this presentation. I'll wait for the questions.
Well, thank you very much. We almost complied with time. I think it's important that LDCs are not subject to requirements. That's an important statement. We can maybe then also go into the discussion, into the question on it's uncontested compulsory licensing works in the internal side, but whether it also works on the external side. And then maybe relating to the new text of the waiver, since it also covers medical goods, what is the breadth of it? And maybe also later on, we might come back to the question of the timeline or the open-endedness of the waiver, and also whether production capacity is resolved by simply having a waiver, but that's for the Q&A session. I turn immediately, I don't see questions in the chat right now. I'm sure we'll come back to that later. So I'm turning, after this excellent first presentation on the key issues of the TRIPS waiver, to Paola Mariani on the export control measures affecting trade in goods and the global COVID crisis from the perspective of the EU mainly. And here it is. So Paola is teaching at Bocconi University, and she is in charge of international law and EU law and the EU and private international law courses. She's focusing on international trade law and EU law. I'm not going to list a lot of her publications, but she's an expert in the jurisprudence of the Court of Justice, and has published also with Giorgio Sacerdoti on the COVID pandemic legal issues. But we will focus now in her presentation on the EU side, both on the internal side among member states, the external side under the common external trade regime of the EU, and make a comparison, draw a comparison to other jurisdictions like the United States. And if it works with the slides, fine. If not,
yeah.
continue.
Thank you very much. I try to share my, oh my God.
And while we are waiting, I'm already noting to Zaman that there's a question by Lothar Ehring. Can you and other speakers elaborate on the security exception, whether it can be invoked? Waivers are only needed or allowed when an obligation needs to be waived. So, for example, if there's no obligation for the LDCs, what is there to be waived? But this will be after the presentations. I'm just pointing out.
Yeah, I'm having some problem in sharing. Oh my God.
Well, let's not worry.
I think
about
that,
it.
Yes.
No, do what she said. Now press on the PowerPoint on the bottom of your thing.
Sorry?
Entire screen, yeah.
She
Yeah,
said, open your screen first and then press on the PowerPoint. That's what she told us to do before, told you to do before.
Okay.
Remember on the bottom?
I try again. Sorry. Okay, now do you see? Are you seeing
Yes,
the?
yes,
oh, okay.
Yes, perfect.
Okay, thank you. Thank you very much for having me. Okay, my presentation and my paper is about the export mechanism that are that we have during COVID-19 crisis. As you can see from this picture, it was quite usual for the states during the crisis to implement export control policies. But and so you see that the majority of states adopted some sort of measure, but my paper and my presentation is mainly about the EU system of export control. Before going into the topic that is the export control system in the case of COVID-19 vaccines, I would like to give just an idea of the system, of the EU system of export control, because in the EU, as usual, the situation is quite peculiar. In fact, we have to distinguish between the intra-EU trade and extra-EU trade, meaning that we have two different forms of control. We can say that the principles and the rules, the basic rules are more or less the same, because we have a general prohibition to introduce quantitative restriction, both in the internal market and with the relationship with other third countries, but at the same time, it's admitted some derogations, and especially derogations in case of health emergencies. So the situation is quite the less. But what is different is let's say the procedural side, because quite surprisingly, the system in the internal market is very much similar to the system of the GATT and the WTO system. It means that the member states are autonomous in deciding to adopt export trade barriers. And in case it's possible that there is a follow-up control, judicial control, but at the beginning it's only the state that has the power to decide if there is a situation justifying a derogation to free trade. Of course, we have union principle and union roles. For example, we have a case law, the principle of proportionality, and a EU definition, let's say, of national standard of protection. But in any case, at the beginning, it's up to the state to decide the measure, the exception, the derogation to free trade. On the other side, if we look at the extra EU system, here we have a supranational system, and that is an export authorization scheme. And this export authorization is regulated by the EU and especially by the Commission. In fact, we have a Commission regulation. It means a legislative act, a binding act for the member states enacted by the Commission. And here in this system, of course, we have uniform rules and principles governing the process of authorization. That is, in any case, a national process. It means that it's up to the state to decide to introduce barrier in the trade with third countries. But what is interesting is that here, differently from the EU internal market, the member states are not left alone, because there is the supervision of the Commission, and the Commission verify if the principle is the EU principle are respected. Coming to the system concerning the COVID-19 vaccines, and more in general, the export scheme adopted in case of during the pandemic, we have two different schemes. The first one was adopted in the first phase of the pandemic, and the second one is it was adopted in January, is still in force, and it's about just the COVID-19 vaccines. Instead, the first scheme is not anymore in place. Why did the EU adopted an export control regime? In the first phase, it was the main reason to adopting an export regime for the EU was because the member states of the European Union were the first to adopt export restriction, and what it was very dangerous. It was that the export restriction were adopted within the internal market. Do you remember that? I think that at the beginning of the pandemic, Germany and France closed their market to the export of personal protective equipment, and it was a very dangerous move, because the internal market and the European Union is a very integrated market, and such a move would have had terrible consequences, in many cases severely hit by the pandemic. And so, because of the system of the EU internal system, it was not possible to have a preventing action from the Union. And so the Commission, since the beginning, made a very strong political pressure on the member states, and in the end, the compromise, in Europe we have always compromises decisions. The compromise was that the member states decided to avoid any kind of restriction within the internal market, but on the other side, they could adopt export control intervention with third countries. The second export regime, the export regime concerning COVID-19 vaccines, was adopted in a very different situation, because it was not about a shortage goods, such as in the first phase. But here it was adopted because of a peculiar situation in which some of the vaccine producer, private company, did not respect the contracts signed with the Commission for the vaccines, and it was adopted for the reason to avoid that there was to avoid any problem with the fulfillment of those contracts. But what is interesting, and I'm coming to finish my intervention, is I think on a more general legal point of view, is that both schemes, what is common in both regimes is that having a supranational mechanism is good in the sense that when the member states assess the threat to the security in the case of the vaccine, of the supply of vaccine, they have to take into consideration not just the situation in the country, in the state. That is the usual way to decide an export control measure when you are in a normal state, in a normal situation of state. But they have to take into consideration also the situation, the sanitary situation in the European Union. And then, according to the regulation, they have also to take into consideration the situation, the sanitary situation of the country of destination of the export. And I think that this is a very good. It's a positive side of this system compared to some situations such as, for example, the US and other countries where their goal is to protect just the internal the country and the safety of the country.
Okay.
Thank you very much, and I leave it here for now. And then of course I'm ready to answer all the questions. Thank you.
Well, thank you very much, Paola, for this very instructive introduction. We can later on explore further the difference under 36 for the internal regime and for the external trade regime, and also the role of private pharmaceutical companies, on which you touched briefly. And also the fact that despite these restrictions, I think 40% of the EU production was exported during that period of vaccines. And we might also get deeper into the comparison with the US regime. But thank you very much. We are moving on to Marcia and Hadas. I understand that Hadas will present today first. And here we're looking at global government procurement governments amid the pandemic. We have government procurement rules in the WTO, in national regimes, in regional regimes, but many of them were respected or not respected during the pandemic in emergency situations. And the presentation will focus on whether the global regime broke down or whether it had sufficient flexibilities. Please, Hadas.
Thank you. Definitely this is what we're aiming to do. And in the context of the discussions earlier this morning, we hear many voices about a backlash against globalization and erosion of international economic law. We look at a very specific area, the global government procurement governance, and we found our assumption is that it actually did not break, it remained quite resilient, and we tried to understand how and why it was able to withstand the crisis. So what we did, basically, we reviewed state responses, we reviewed the main 5 treaties, and we examined the level of flexibility in the state policy space.
Hadas, you didn't move the slide.
Okay. You don't see the slide moving?
No, we're still looking at the title slide.
Okay, wait. It shows that it's moving. Wait.
Now we don't see the slides anymore, so maybe you open again and then maybe you go at full screen and then maybe the slides will move. Yeah, you're back with your slides and now you're the second one. Perfect. Continue.
Second,
please.
okay.
Yes.
So, so just one more, just a caveat, because we're still in the middle of an ongoing pandemic. So you will see in the end, we still need to revisit this in the future. So basically, as you mentioned, we see some common features in state responses. We see this in the work of OECD, of the World Bank, and some preliminary reports by various governments. We see a general trend for rule relaxation regarding changes to contracts, time limits for suppliers to implement contracts, but also for the procurement process itself. We see rule relaxation regarding the time limits to submit the tender or to we see relaxation regarding negotiated procedures. You don't need to have prior publication. And there are many, many examples, transfer authority to other entities. And some countries are now trying to provide some guidelines how to deal in this emergency crisis. What we're trying to understand is what is the view from the perspective of the global governance of government procurement. Do you see the next slide?
Yeah.
Okay. So basically, the global governance of government procurement is based on the WTO GPA. This is the backbone. It is the this treaty is the text is from 2012, but the history goes back from the 80s. And the text itself has a lot of flexibility in itself. It has room for limited tendering, meaning not open or selective in case of crisis when it's necessary and there are reasons of extreme urgency. There are also some flexibility for time periods, for shorter time periods permitted in a state of urgency. And there's a general exception under Article 3.2a, which allows parties to necessary to protect human life or health, the general exception to the treaty. And also we must remember that the architecture of the GPA opt for for dispute resolution, which is mainly managed at the domestic level with a limit of on compensation. So when we look at other treaties that we surveyed, the USMCA, which is a binding on government procurement between Mexico and the US, the CPTPP, and the TCA, the Trade Cooperation Agreement between the UK and the EU, which takes a pillar of the GPA, but then extend it in addition. We also find, a lot of room for flexibilities in time of crisis. And RCEP, which is not effective yet, but still it's going to be a future trend, actually has a very limited scope of obligations related to limited requirement on transparency. So this means there's a lot of maximum flexibility for future policy space. I just want to show you how we did that. Do you see the slide? So generally, when we try to provide some character to the different provisions in the different treaties, we imagine a continuum. We interpret each treaty by itself. It's the Vienna Convention, and we believe that countries try to meet their obligations. This is pacta non servanda, but we try to really identify with the different elements of the treaty, where do we find that policy space? So this is you can see the continuum that we reviewed for each of these surveys of these treaties, and I don't have time to go into the specific detail of each of those treaties, but generally speaking, the trend of the GPA is applicable. So what can we learn from it? A few things. If we see how the system functioned, we see that it was quite resilient. Many countries declared some temporary time-limited measures departing from the ordinary procurement processes related to COVID-19. So states were aware that this is only a temporary factor. This may be related to international obligations, but this may also be related to some national, domestic outlook to comply with the local legislation. But what we also see, which is really interesting because it's more than a year since the pandemic broke and so many procurement rules were changed, still there were no formal complaints that were filed criticizing domestic government procurement measures taken during the pandemic. And this actually goes, fits, the trend overall, because generally speaking, we see lack of disputes over government procurement throughout and the history of government procurement global governance. So apart from a case of the US that tried to change the scope of coverage in the schedule, which maybe Marcia can refer to it later because I want to meet my schedule. Really, there was no unsatisfactory voices between the different parties. So lessons, generally for the global governance of international economic law, we see that, still government procurement has harmonizing effect. There's a common understanding. It provides common understanding between the different states and private stakeholders about rules and procedures. It promotes consensus on transparency and competitive domestic procurement. Still, it allows flexibility, and we see 1.5 years into the pandemic that the regime remained resilient. The big question is really to further integrate more ESG into government procurement, and this is a challenge which is being dealt by every system. And the second question, what will be when we are over the pandemic, and whether the system will come back to the way it functioned, and procurement will come back to the way it functioned before the pandemic or not. So I think I'm basically on time. Maybe Marcia can continue the discussion.
Thank you very much. Marcia, do you want to add something right now, or we rather wait for the discussion?
Yeah, let's wait for the discussion.
Okay. I should also apologize. I was looking so much at the watch that I forgot to introduce your CV. So Hadas Peled is from Ilan University in Israel, and she also studied in Tsinghua and did her LLM and PhD in Chinese law and investment law and dispute resolution. And she's teaching at that university in Israel. And Marcia Harpaz is a lecturer for international relations at the Hebrew University in Jerusalem. And she was also working in the in the Israeli government, the Ministry of Economy. Maybe if we summarize, and I could later on in the Q&A session, we could also draw a comparison between Paola's presentation and Hadas' presentation, because one question that arises from the way you just described the government procurement regime is, are we going in these flexibilities then for a total opt-out, or what are the strings attached in emergency situations that rules are flexible but not completely without strings attached to them? We see this with Article 36 in the EU Treaty and the external trade regime of the EU. And we saw this now also the final slides on the government procurement code and the comparison to the regional instruments Hadas analyzed. That may be one secret of keeping flexibility, but also supranational or international constraints, is that obligations continue to apply, but to a lesser extent.
Yeah, I think that the same question as Paola's, because I think the question is whether the countries are going to consider it temporary.
Exactly.
I think the legal strings are there.
Exactly. So we can continue this discussion.
In both cases.
Yeah.
And I can say, from Paola's, I can already say from her presentation, that it sounds to me like some of their measures have been temporary. They were, she said one started until January and then a new one in January. So there's an awareness that these are temporary and that the default is one thing and that the exemptions are something different. So I actually think that was one of my questions to Paola. Do you think that they'll keep it temporary or not?
Right.
Yeah.
May I just? No,
sorry.
Okay, I will answer later. Okay.
Yeah. So if I may say, we continue this discussion, please. It's good to raise questions, which I'm also doing. You get time to reflect upon it, and we will get back to that after Davide's presentation. And I also draw your attention to Amy Porter's question in the chat, which is quite interesting about, of course, the US was at some point during the Trump administration thinking about renegotiating the GPA. But with that, I'm turning to Davide Zoppolato from University of Macerata, West Virginia, and he also studied like Hadas in China, in Beijing University, and also in Turin. And I think his presentation is a nice conclusion of this sequence because it focuses on more general questions of how to analyze all this. We're in a pandemic situation, but beyond that, is the WTO being marginalized in international trade, given the lack of negotiating results, and with the backlash on globalization, the debate about nationalization and reshoring is a general tendency far beyond particular US presidents. So since you have lived in China and researched on China, it will be interesting to draw the link from the EU to US and now also to China. Please, Davide.
Thank you for the kind presentation, and thanks to all the speakers for the insightful presentation. So I will move to a more theoretical level, and I'm trying to connect how the role of the state and the market and the relationship between the state and the market is changing due to COVID-19. The state rediscovered itself as an economic actor, and the regulator due also to the inability of the market to provide the needed PPE. Further, to the first point of contact between the citizen and the pandemic, both at the national and subnational level. Rather than facilitate trading goods, many governments across the globe, as the map of Professor Mariani was showing, restricted trade. But the temporary quantitative restriction have a specific aim, that is to provide goods for the national population. So this is also undermining the key tenets and the key assumption on the global trading regime and also of multilateralism more in general. What was missing was a coordination since the very start, not only from a multilateral level, but also at a regional level. But COVID didn't change everything, because the core priorities of the multilateral trading regime were already shifting before. What COVID did was to speeding up these changes. Because if we think about opening new market and reduction of tariffs and non-tariff barriers to trade appear to not to be anymore the core priority of some European countries. Now consumers are much more taking into account where the goods are sourced, for example, food, on the emission that manufacturing is creating for the global environment. In this research, I will try briefly to cover export restriction, but I will skip that thanks to Maria's presentation. And then I will move to nationalization, reshoring, and China's answer to the pandemic. We use the same map here to show also what was during the first phase, especially during the 6 months of the pandemic, from January to July 2020. The common and basic understanding was that the only way in order to provide PPE at the national population was to control the market, and was for the state to enter in the market and drive market forces, even with procurement. One of the key problems was also keeping track of all these goods and all of these measures that were sourcing from China or from other countries, because face masks, for example, fall in different HS code. So it was even difficult to get data on the topic. Here I try to collect like the main export restriction that took place in the first 6 months, and I try to place like in 3 broad categories. One is prevention, so goods used for the COVID-19, food, and treatment. So let's maybe just look at the role of the WTO in this context. That was transparency and to better understand which kind of measures were enacted. Regarding like the exception, as Professor Mariani was covering, like there are several exceptions that can be used to justify like export restriction, even because they are temporary in like timing. Like for example, like if we look at Article 20, the general exception could apply. And we also need to think about that no members filed complaint against like a temporary export restriction because we were in the middle of a pandemic and we still are. So the WTO like created in the website where we collected not only like the notified measures, but also other measures, other restrictive measures to increase transparency and bring up like a cooperation between members. But the real problem that we will see is going to be like the next phase, the phase that we are entering as like the global north right now, the one of economic reconstruction, because the amount of funding available will change like the relation between the state and the market, and we will see back probably like industrial policy. And there is also a realignment of trade priorities between like the European Union and the US, also in order to constrain, meaningfully constrain like the rise of China in the global order. Let's look briefly at nationalization and COVID-19. This picture is kind of interesting because it's like based on Google Trends, and straight after the pandemic in March, middle of March, nationalization was a key term trending on Google. And the other one is like the difference between privatization and nationalization, also divided by country. So nationalization was used as a discourse straight after the pandemic by many politicians across Europe. And also the first governmental decree that addressed COVID in Italy contained a provision that allowed the government to nationalize Alitalia again. Also, other countries like in Europe did the same, like Germany and the Netherlands with KLM and Lufthansa, United Kingdom nationalized the Great British Railways, Spain the private healthcare, and so on. What it arises clear is that like there are some specific sectors where the state entered directly into the market: transportation, health, and energy. And also the most part of like EU Commission approved state aid fall into these categories. But the state was already present in this sector before like the privatization wave of the 90s. But beyond the strategic sector, even if there were numerous calls like to use like the nationalization tool in order to speed up like vaccine production, PPE, and so on, no nationalization took place after the pandemic and even now. So the Havana Charter like took into account that in some cases the presence of the state in the market is essential to reach social goals. Under the World Trade Organization framework, under the Marrakesh Agreement, the stance was more based on the neutrality of the owner, and it's the same also in the European legal framework. Under the WTO legal framework, we have the concept of state-ready enterprises. Under GATT, there is the concept of public body that could cover in some way like state-owned enterprises, and so on. Right now, like in a new preferential trade agreement, the issue of the state into the market and of SOEs, especially to counteract China, is taking place. And they are much more like interested in covering this kind of behavior. For reshoring, even reshoring was a trend that was taking place before like COVID-19, but many companies are now more interested, even thanks to the funding available, like to reconstruct the economy. The issue is that like reshoring, if is a business decision, is difficultly covered by the World Trade Organization. Only in the case of subsidies, direct financial contribution to the company in order to reshore. And for the Chinese answer to the pandemic, China took a very different stance on the topic. China tried to facilitate at first the import and export of face masks and PPE, and also cooperate with state and non-state, formal and informal actors to speed up the procurement. There was also an important role of a proactive business sector and middlemen that were trying to trade face mask and PPE. The government entered straight after, like in April 2020 already, in order to contain the backlash against the quality of Chinese goods. And they issue a notice where they require these two forms to be filled in order to guarantee the quality. The notice also contains something like strong monetary penalties, a blacklist system for the company that did not abide to the quality regulation, public shaming on WeChat, where the companies that did not abide to the quality standard were published their name on the WeChat account of the customer. And here we can see some message that I get from Chinese friends and so on, and from this kind of middlemen that were trying to trade face masks and goods. So trade facilitation was really important for China, but you addressed the manufacturing and national production in a later phase. The first phase, when the government entered, even to counteract the pandemic, was more focused on giving to the general population control of the pandemic via lockdown measures and so on. But even when they enter in the market to speed up production of PPE and so on, only few of the companies that received subsidies, for example, in Italy, are still manufacturing this PPE. And the Chinese answer to the pandemic reshoring issue is that China is offshoring, thanks to the Belt and Road Initiative framework, is even investing in neighboring countries, and is supporting circulation of capital and goods. More recently, even as a consequence of the COVID pandemic, there is this new concept that is gaining attention in Chinese policy circle, that is the one of dual circulation. And this is also under the draft of the new 5-year economic plan. And the idea is to reinforce the internal market, while at the meantime keeping the strength and the power of China in the international one. So I think that I'm already out of time. Sorry for that.
Well, thank you very much.
Thank you for your attention.
Thank you very much about the slides, the cartoons at the end. That's
from China Daily.
From China Daily.
The situation of the current global economy. This one is at least optimistic.
Well, I think this was a very interesting presentation towards the end now regarding linking this back to the WTO system. And I think we may later on deepen the discussion on how the state trading rules of the WTO, the current ones and what they should be, have an impact on this. And maybe also the question whether the question of shoring or reshoring is different for medical goods versus vaccines. When it comes to medical goods, the production in the West in developing countries is different than from the vaccine side. And maybe we can also deepen the issue about the discussion of the dual circularity. But before we do that, we should now, I think we did reasonably well on time. Thank you for that. We have a full half hour for Q&A, which is at least better than in other sessions, I'm told. So we may be going back to the first topic regarding the TRIPS waiver. So a lot of the discussion by Khorsed, Zaman was about the compulsory licenses and the waiver of the TRIPS amendment, but of course we have now a different proposal that is much more broad. And maybe one first question would be, obviously when LDCs, there's a question in the chat, when LDCs are not subject to certain obligations, and that's also a misconception that just recently came up in the TRIPS Council here in Geneva. If Bangladesh doesn't produce more, it's not the question that they are not allowed to. There is an LDC not subject to certain rules. But maybe we focus on the question on the export side of the compulsory waiver provision, because there's this provision in 31Bs and in the annex, when a country declares that it doesn't have the proper production capacity itself, it can enter into a deal with another country for supply. So that seems to suggest exports are permitted. And maybe I would invite the first speaker, I would invite Zaman to also respond to Lothar Ehring's question about the security exception and how it can be invoked. So Article 73 of the TRIPS agreement, taken in times of war or other emergency in international relations.
Can I ask two questions also?
Sure, sure.
One question is, why are Western countries against the waiver? That's number one. I mean, it's been coming out in all the papers and everything that they say, well, it doesn't matter because they still don't have production capacity. So what's behind it? Why are they really against it? That's number one. And number two, if you put aside the legal questions, in Israel, we were trying to figure out what our position is. I mean, I know that we need to figure it out. And I'm wondering, wouldn't it show support for the multilateral trading system, not just developing countries, if we support the waiver? I mean, it would be good for developing countries because we're all in this together, and COVID is never going to go away unless everybody gets vaccinated. So I'm thinking, just even as a sign of political will and support for the multilateral system, wouldn't it be good?
Okay, so you have three areas of questions. One, the export side, the annex under the TRIPS amendment waiver 31Bs and the annex. Two, the question about national security 73. And then three, and I'm thankful to Marcia for raising the new waiver proposal. I think it's something we need to discuss.
Okay, so can I go one by one? First of all, regarding export, yes, like COVID-19 products, pharmaceuticals, can be exported if it is produced under compulsory licenses that can be exported. I'll come back to that point later. But I think Lothar's question is very important in this context, which is, can national security exception be used in this case? Simply, the answer is yes. National security can be used to invoke compulsory licenses. It's already been used, not national security. Compulsory license has been already used by Israel for the first time in COVID-19 situation. Okay, that's one thing. But national security, Article 31B of TRIPS permits that on the ground of national security, compulsory licenses can be used. That is one provision. There is another provision in TRIPS, which is Article 73B, subsection 3. That also allows WTO members to use compulsory licenses on the ground of national security. But interestingly, I mentioned in my presentation, these are two grounds to use national security. WTO jurisprudence is inadequate in this respect. What is the relationship between Article 31B and Article 73B, subsection 3? Are they different or are they the same? So we need clarification. That's why WTO TRIPS Council or WTO General Council probably should issue a clarification on the relationship between these two types of national security. But for sure, national security can be used to issue compulsory licenses. National security issues under TRIPS has never been questioned in WTO dispute settlement, except twice. There are two cases in WTO dispute settlement body. One is Ukraine versus Russia case, and the second one is regarding the Middle Eastern case, United Arab Emirates versus Saudi Arabia. These two cases are recent case, and that happened only in 2020. So national security issue is very hot cake. It's a very recent issue in WTO. We need clarification. We know it can be used, but how it can be used, we don't know. And we need clarification from WTO. And that clarification is very essential. Even the waiver is not essential. This clarification is essential. So that was my answer for Lothar's question. Can national security be used? Yes, it can be used. And the second question was regarding LDC. I think Werner answered that question. LDCs are under waiver. They do not have any obligation for applying, implementing, enforcing. So they can do whatever they want to do. But unfortunately, LDCs like Bangladesh and other countries, they do not have the capacity to produce vaccines and pharmaceuticals for COVID-19. If they can do that, there is no legal barrier. There is no legal barrier. Okay. Marcia's question, why Western countries are opposing it? Because protection of intellectual property rights. That's a big politics. Political economy, I would say, not politics. So it's political economy. That is related to inclusion of trade-related intellectual property rights into WTO. Why it was included in trade? Why intellectual property was included in trade? So the answer for this question is related to that thing. Sometimes developed countries, they love to protect pharmaceutical industries' interest more than other countries. And that's why they want to ensure intellectual property rights for research and development. All those that is essential, undoubtedly. And that's why Western countries, they have more interest in protect, because they have more research, they have more development, they have more industries, so they have more interest in protection.
Okay. Well, thank you very much. I think we see also in the chat one quick answer to the relationship between 31 bis and 73 is nothing in this agreement shall be construed. So it seems one quick answer would be 73 applies on top of 31.3 bis. But we have also had cases in agriculture with GATT and agriculture agreement that can be sometimes more tricky. And maybe just, I want to reserve enough time for the other presentations, but also as a quick answer. So it's very important what you said, Zaman, about the LDCs not being subject to obligations. The export side, so there is flexibility under the annex. And to Marcia's question, if I may just quote a little bit from the TRIPS discussion, I think there's certainly the concern that sort of the floodgates on IP protection are breaking once you agree to such a waiver in one area. Yeah. That may be overblown, but I think one part of the discussion in WTO is also that the new waiver, the revised version especially, is very broad in its reach. Medical goods could be very broad, and patents and vaccines, and also part of the question is what is the timeline, because it says during the time of a pandemic, which becomes then a self-judging exercise for each question, for each country. And then finally, one part of when you look at the speeches of the DG and the presentation of the EU proposal recently is enacting a waiver changes nothing, for example, in the situation of Bangladesh if they don't have the capacity. So one way of looking at it, maybe you should do it, but you would in addition still have to do something about production capacity, because that doesn't come automatically. And we have heard in Zaman's presentation the limits of the compulsory licensing system. We heard the debate about the missing production capacity, but also the missing inputs. Maybe I can shift then to the second and the third presentations. And I apologize again for having cut off Marcia a little bit with her questions that you were asking to the EU regime. I think we could maybe take this discussion a bit together, address it together, because in both regimes, government procurement and in the EU regime, internally and externally, and maybe in comparison to the US, we're looking at flexibilities in the treaty and how much judicialization or judicial constraints are still attached to the emergency exceptions internally, externally, and under the GPA regime. And maybe we can link this question, maybe Marcia, you complete your question you were going to ask to Paola, and maybe Paola, you could then react to the GPA presentation, and then we could take Marcia or Hadas the question by Amy Porges about the US attempt to renegotiate the GPA. Marcia?
Yeah, so now I'm trying to remember what I was asking. What we were struggling with in our paper, when we're writing our paper, is what, and again, this actually relates to what I was saying before on the first presentation. It seems to us that there's enough legal protections, in both. Emergency measures are only supposed to be taken in emergency cases, and we found in our study, just like you found in yours, that countries were limiting the times that they were putting into effect these measures. So the question that we have is, and actually Werner asked us in his questions, what will indicate that the system is finally okay? And so we were struggling with the answer, and they said, well, what will indicate the system is finally resilient or okay is that countries, we did a metaphor like an accordion. Like the accordion opens up for exceptions, and we found a bunch of three exceptions beyond. I mean, we found some exceptions beyond what people usually talk about, more than limited tendering, more than the health exception. And Hadas mentioned it about the way the domestic procedure works. And then we also talked about objectives, how they've started adding to the objectives of the preambles of the various agreements, things that have to do with health. So the question is, so we thought of it as an accordion. Is it going to contract again? Is the accordion going to contract again? So we sort of, in a preliminary way, conclude that yes. And that's one of the reasons that we're saying that the government procurement agreement is resilient, because it's got the protections in if you need them, and it will contract again if we don't. I mean, and that's our huge question. If we need more protection, and or insurance, or ways of ensuring that it will contract again. And the question is it enough? What exists, or do we have to put in more that has specifically to do with health? Because they've been putting a lot in to do with environment in all of the agreements that we looked at, and Hadas highlighted that. And also the GPA, the revised GPA, added things about environment. But health specifically was only, I think, in one of them. I don't remember which one of the agreements we looked at. So okay. That's my comment question to
okay. Over to Paola.
Okay, thank you. Yeah, I think that the system, the European system worked and is working quite well, especially the external, because I think that in the end, an authorization scheme is a very good way to manage export restrictions. And if you look at the implementation, you can see that the refusal of authorization to export are rare. For example, in the case of the vaccines, there was only one case reported. And here again, the problem may be transparency, because we don't know exactly if it's completely transparent, the system, but apparently in the European Union, in the first scheme, it was really, really transparent because we have all the information. For the vaccine, it's just the information provided by the Commission, not concerning the single transactions. But I think that in the end, the system is resilient and is good. What, in my opinion, what is not very strong is the internal system of the European Union, because we know in the end the Commission, I think that made a very good job and to reach the consensus of the member states to avoid barriers within the internal market, but it was a political decision. I mean that there is no preventive mechanism, and maybe we need also a similar system, not just for the external trade, but also within the internal market. And of course, I come to the Werner mentioned something about judicialization, and for the until now, we have just some opinion, but not public, of the Commission about, and so a sort of administrative control on the measure. And fortunately, I can say we don't have judicial decision on the proportionality of the internal of export control in the internal market, because we didn't mention, but one of the big problem is that in a very integrated area as the European Union, you don't have barriers, and so it's impossible to find a country that is autonomous. You need to have the open market in order to have a fair circulation of goods, and you know, this is the same also for the vaccine, because in the case of vaccine, there is no one country that is autonomous in the production, neither the European Union. For example, the European Union, for some part of ingredients and some part of goods necessary to produce the vaccines, and this is in some way it's a positive thing, because this the supply chain, the real global supply chain, prevented an abuse of export control.
I think that's a very important point. I mean,
measures, but what I fear that, and also listening to the interesting presentation of Davide, Dr. Zoppolato, is that in the end, you know, that one of the goal of the European Union, for example, is to shorten the supply chain, is to try to internalize the production, and I don't know, maybe it's not so good, because if you are not dependent on the other countries, you are more tempted to have barrier. And you can see this in the US. Maybe the US is the only player having a sort of autonomy in the production of, even if not a total autonomy, by the production of the vaccines, and they were very, very strict in the export. They did, and they prevented also. They made there was a lot of problem also for the Indian producer of vaccine during the emergency in India, because they don't export the ingredients that was necessary to produce the vaccine. So
I think, well, that's all very interesting. I would like to come back to that topic when we turn back to Davide. I think one feature of difference between the internal and external regime of the EU is that Article 36 is left to the review of the European Court of Justice. Now there's a jurisprudence about that, while some of the supranational, some of the export restraints on the third country side, as you explained, were done by the EU Commission. I think that would be also interesting to look at where the weight in terms of review and flexibilities would be in the government procurement area. And I think, and I'm flagging this to Davide, because after we go back to GPA, I would like to bring together the aspect of the EU situation where it seemed that the Commission was not capable of really controlling ultimately the exports by the companies. So there was the pharmaceutical companies that dependent on the supply chains. I think it's an important point that Paola made about one resilient factor was not the legal regime, but also the supply chains that are hard to nationalize. And we could maybe make a link and discuss this from the European perspective, but also from the Chinese perspective in terms of the state influence. One part that in the reshoring slides was debated by Davide. But before we get there, maybe Marcia or Hadas, maybe Hadas, you come back to the question that was raised by Amy Porges about the government procurement code. Would it have been better to renegotiate it to accommodate the Trump period executive order countermeasures? What is your assessment of this tough choice given by that question? And then I'll like to also to government procurement.
Well, Amy, it wasn't exactly renegotiating. What they wanted, they wanted to modify the schedule. The U.S. wanted to modify its schedule. But there are two issues. The first issue is that Hadas had in our slide was that the United States in the GPA committee was challenged for its executive order. So then the question is so then Trump went to the Trump administration went to the committee and he applied formally for a modification of the United States schedule. So the thing is, he really didn't need this modification. And he was asked a lot of questions, or the United States was asked a lot of questions in the Government Procurement Committee about this modification, because it's an actual legal change. And what happened is that under Biden first started giving all the information they needed, because the country started asking how much we're talking, how much money are we talking about? And then the Biden administration backed down on that. So the question is, did they need the modification? Obviously, we don't think that they needed the modification. That's number one. Number two, Hadas and I happen to be present at a webinar, which is under Chatham House, so we can't really say who said it, but somebody said all it was Trump trying to cause trouble in the committee with the European Union. So, I mean, obviously, if that's true, even the United States didn't think it needed that modification to cover its back. Anyway, so
well, thank you very much. I think that was a good answer. I might come at the very end back to the second question that was raised by who was it? Senai and Mariani about interaction WHO, and also the question about technology transferred by Michelle Limenta. But before we go there, we might want to go back to Davide. So we've seen in the EU the situation that maybe comparatively to the United States, where the executive branch could and did enact export restrictions without much constraint. In the EU, we had the judicial control, and we had also the difference between the emphasis on the judicial branch versus the executive branch in the internal market versus the external side. But there was also the resilience of the supply chains, because the pharmaceutical companies are dependent on each other in terms of inputs, in terms of technology. If you're thinking of the EU situation, how does that square with what you identify in China? Because in your slides and your presentation, you also focus not only on the government response, but also on the role of state-owned enterprises here.
Yeah, the point is that I believe with the funding available under the recovery fund at the European Union level, and the main priorities that the EU recovery fund listed, the focus is going to be on infrastructure and emerging technologies, European infrastructure and European emerging technologies. So it's kind of sad to say that, but also the reapproach Biden administration is going to increase the difference with China and the other part of the world. We are building also with the new initiative launched by doing the Cornwall Consensus at the latest G7. There is a new consensus between Europe and China that wants to focus and strengthen the partnership and exclude. And so I'm seeing that I think that the issue of modern state-owned enterprises is going to be like a huge investment in general infrastructure and in the European Union that could be easily justified by the Article 1 of the subsidies and countervailing agreement of the World Trade Organization. So this kind of financial contribution could be used to strengthen like a core European, let's hope European, not national-based businesses.
Okay, well, thank you very much. I think that's an interesting perspective, and I think it leads together to maybe the final question. You know, there was this question raised by not only one in the chat room about what is really the solution now in terms of technology transfer. Now, one aspect is certainly finance, and I think Davide just mentioned this. There are now attempts, joint ventures of European. There was a big meeting, World Bank, WTO, hosted by France, about putting billions into production capacity into developing countries. Now, one of the chat's question was about, you know, is it technology transfer? Yes and no. I mean, if you properly register patents in a developing country, you will have to have left with the patent office the precise description of the patent. So if you do compulsory licenses, and we are getting back to Khorsed Zaman's presentation, are the current flexibilities not sufficient? Maybe not, but there is a lot that can be done with the architecture of 31Bs and the flexibilities we have under the TRIPS agreement. So access to that description of the patent should be there, but then the real issue becomes production capacity. There's the issue of finance, and then there's the issue of the supply chains that depend on inputs that no country alone would have. So technology transfer, yes, but I think the real question is then, how do we build up production capacity, especially for vaccines in developing countries? And then emergency situations, we see that there is a jurisprudence on and some strings attached. I think we have the flexibility in the EU treaty, in the government procurement code, that allow for restrictions, but also try to attach conditions on it. So maybe we are running out of time, but maybe I invite each of the presenters to, if you wish so, to give your view on the overall question, how this production capacity issue and in developing countries can be resolved. And I'm pointing your attention also to the intervention by Jan Bohannes. There's a national security question, but maybe we wrap all this together, and we're looking now from your experiences with GPA, with the EU regime, with the Chinese regime, and with the waiver, the old one and the new one, looking at government response and private sector response, where do you see the solution? Who wants to intervene? Maybe I pass the floor again to Khorsed, and then to Paola, and finally Davide can conclude after Marcia. Can you unmute? Yes, I can hear you now.
Actually, lastly, what I want to say that there is no straightforward answer to this problem. It depends on WTO membership. If they behave with positive approach, everything can be overcome. So we can overcome everything if everybody, all WTO members, think very positively and follow Article 31Bs properly, objectively, then I believe there is no need to have a new waiver. The existing waiver can work. And if we think very pessimistically, then hundreds of waivers will not work. First waiver, second waiver, third waiver, maybe multiple times we need waiver, that will not work. But we need some clarification. As I said, some issues like some articles, some regulations are not clear enough. That should be clarified. And if those are clarified, I think the existing system can work well. We don't need any more change. That's all from me. And now I'm passing on to others.
Thank you very much. I have now time to read the chat comment. I think it points out why national security exceptions, of course, have a huge reach potentially, and maybe it could be even more broad and broadly interpreted under the TRIPS agreement and the litigation we had on GATT or services. So maybe Paola, you want to have a final word, followed by Marcia,
Yeah.
and then Davide.
Yeah, no, on your comments, and Marcia, I would like to say that I think that the European Union in this moment is more concentrated in expanding the productive capacity, for example, in vaccines. And so this is why maybe there is this position against the waiver, especially from Germany, because Germany and many states, Belgium and many European states, are very involved in this enlargement of the production capacity. And so it's also a question to protect your business in one way. But I think also that it's not, if you want to improve the production capacity in the vaccine in the developing countries, in the low-income countries, you need a long-term program, because I mean, it's not just it's not a simple production. So maybe in this moment, in which we need a huge production in a very short time in order to fight pandemic, maybe it's the best solution is to have a strong production, a very huge production in the European Union, for example, because the European Union is the main exporters of vaccines, and maybe to support the low-income countries to buy the vaccines at a very fair price. I think this can be the solution. Of course, we need in the middle and the long term, we need to expand the capacity also in the other countries. But in this moment, maybe this can explain also the position of the Union.
I think that's very well taken. Certainly, the production capacity in the EU is higher, so the export capacity, but it doesn't change the fact that I think less than 3% of world production capacity of vaccines is in Africa. I pass over to Hadas. You haven't said much yet in the discussion. You want to add a final word, looking at your government procurement perspective in terms of the solution to the problem?
Okay, I want to say 3 sentences. One, trying, as a continuing question for all of you, we discuss vaccines. The WHO is running, with information on the different countries who applied for a vaccine approval. And one of those countries is Cuba. So when you do all this discussion and trying to, I think, you know, if you neglect this point, then you know, something is missing in the discussion. But going back really to our presentation, and this was also due to time constraint. You raised a question of how do we enhance capacity, and one of the global governance of government procurement is actually a transfer of knowledge and information. And because, in fact, you know, governments are quite, you know, paralyzed by the challenges. So they do want to cooperate. So you have 3 pillars to the regime, and actually you have a lot of knowledge transfer by OECD, by the OECD group and some other groups, which is readily accepted. And if you see the success of the UNCITRAL code in comparison to other areas, you see it's quite successful because it really tries to solve a problem and to help some countries. So I think generally speaking, at this time, and this, I had my share in China, I think, when too many things are moving, if we try to approach something, I listened to the discussion earlier this morning, no one can agree on how to resolve dispute resolution globally. So I think if we take a step-by-step approach and learn from the government procurement experience and focus first on really like streamlining the domestic measures. So a company from Israel can go for I don't know, a tender in China and still understand the concept, the timeline, and what is going on in the processes. I think this will certainly assist in capacity building, and also China is now changing its government procurement rules for medical and pharmaceutical. So generally, I think, you know, if we make a modest, you know, success, that will be a great success at this time of a pandemic. From my own outlook, that's it.
Thank you very much. I think these were very interesting points, pulling together a lot of aspects. Marcia, do you want to add something, or should I pass over to Davide?
Fine.
Yes, thank you. So Davide, I leave you the final word on pulling this together. I think the question of the role of the private companies, the global supply chains and government interference or influence links actually it's problems that are faced both in the West and in China.
I think that what we really need is more cooperation between private and public actors in order to strengthen like cooperation and improve like capacity also in like host countries. Because what we are kind of missing in Europe is that the cooperation between like public administration and private actors is not always like the best possible solution. And also regarding like the issue of capacity building production center like in the global south, the issue is money. Like we need to mobilize money because like right now, European Union and the US are like putting like a huge amount of capital like for national economic reconstruction, not for the rest of the world. And we need also to overcome that kind of development that we used in the past. But we need money, technology transfer, and better cooperation amongst like private and public actors. And we can also learn from China, as Hadas was saying. And we also like work on the competition between the West and the East to provide capital like for developing countries.
I think that's a very, very good summary of what our challenges are and possible solutions. And I think we can also see that as much as there's a debate about state influence in the economy, and we have looked at China, and two of you have studied there, the pandemic has shown that in all countries in the world, the government is back in such emergency situations. And when it comes to solving the global south problems in access to medication and vaccines, public financing, technology transfer, clearly we have market failures that governments will have, and internationalizations and international cooperation will have to jointly address. But I want to keep this very short. I think we're running a little bit over time. I'm not sure how the other sessions are timed. I just wanted to thank each of the presenters. I think it was a very interesting discussion already preparing for the session today. I thank you for keeping quite well with the time constraints, even though you had so much to say, and I know that your papers are even more rich than your presentations. I hope we stay in touch. It was a very interesting discussion. And I would also like to thank the organizers, the invisible organizers, for inviting us to speak, to moderate, and for making sure that this platform works, to my big surprise.
Yeah. Thank you very much.
Thank you.
Thank
you very much.
Thank
Thank
you.
you for moderating.
Thank you, everybody.
Bye-bye.
Thank you, everybody. Thank you,
Bye-bye.
Werner.
Ciao.
Bye. Ciao.